Alright, 119th Congress, first session, Senate 394, to provide regulation payments, stable coins for other purposes within the Senate of the United States with the February 4, 2025. Margaret Hargitay, Mr. Scott, South Carolina, Mr. Gillibrand, Mr. Lums introduced the following bill, which was read twice, referred to the Committee with the Banking House and Urban Affairs. A bill to provide regulation pay stable coins, other purposes of the being enacted, Senate House Representatives of the United States with the Congress assembled. Section 1, short title, the Act may be cited with the guiding establishing national innovation with the U.S. stable coins of 2025, or Genius Act of 2025. The definitions in this Act, Bank Secretary, terms of the Bank Secrecy, in this Act, Bank Secrecy Act is in Bank Secrecy Act means Section 21 Federal Deposit Insurance Act, Title 12 U.S. Standard Code 1829B, Chapter 2, Title 1, Public Law 91508, Title 12 U.S. Standard Code 1951, Intent Sequence, Subchapter 2, Chapter 53, Title 31 United States Code. Board, the term board means the Board of Governors of Federal Reserve System, of the Federal Reserve System. The term comptroller means with the comptroller of currency, with the comptroller regulated, and with the term of the comptroller regulated entity means the federal qualified non-bank payment stablecoin issuer that is subject to regulation supervision exclusively by the comptroller, pursuant to Section 487. The corporation means the term corporation means Federal Deposit Insurance Corporation. Digital asset, with a digital asset means with any digital representation value which is recorded cryptographically secured distributed ledger. The distributed ledger means with the technology where the data is shared across the network creates a public digital ledger. A verified transaction information among network participants with the data linked with a cryptographic maintain integrity with the public ledger. They execute over the function federal qualified non-bank payment stablecoin issuer. With the term federal qualified non-bank payment stablecoin issuer means with a non-bank entity approved with a federal payment stablecoin regulated pursuant to Section 5 of the issue payment stablecoins. Institution affiliated to partner with respect to the permanent payment stablecoin issue with the term institution affiliated to partner means any with a direct officer with the employee with a person control of or agent thereof the permitted payment stablecoin issuer. Insured depository institution with the term insured depository institution means insured depository institution as defined in Section 3 Federal Deposit Insurance Act, Title 12 U.S. Standard Code 1813. Insured credit union as defined in Section 101 Federal Credit Union Act of Title 12 U.S. Standard Code 1752. Monetary value with the term monetary value means national currency or deposits as defined in Section 3 Federal Deposit Insurance Act and was denominated with the national currency. In a national currency. National currency with the term national currency means the Federal Reserve note as termed for the first undergraduate designated paragraph Section 16 Federal Reserve Act, Title 12 U.S. Standard Code 411. Money is issued with a central bank and the money issued with an intergovernmental organizational pursuant with a degree in one or more governments. Non-banking entity. The term non-banking means a person that is not insured with a depository institution or subsidiary insured depository institution. Payment stablecoin with the term payment stablecoin means digital asset that is or is designed to be used as means of payment of settlement, issuer of which is obligated to convert with a redeem repurchase for a fixed amount of monetary value. Represent with a will maintain it creates with a reasonable expectation that maintain a stable value and relative to the value of the fixed amount with a monetary value, and that is not national currency security issued by an investment company registered under Section 8A of the Investment Company Act of 1940, Title 15 U.S. Standard Code 80A and -8A. Permitted payment stablecoin issuer with the term permitted payment stablecoin issuer means a subsidiary insured with a depository institution has been approved with the issue with a payment stablecoins under Section 5. A federal qualified non-bank payment stablecoin issuer that has been approved to issue payment stablecoins under Section 5, or a state qualified payment stablecoin issuer. A person, the term person means an individual, partnership, company, corporation, association, incorporated, unincorporated trust, estates, cooperative organization, other any primary federal payment stablecoin regulator. In general, the term primary federal payment stablecoin regulator means respect to the insurer of the depository institution other than an insured credit union or a subsidiary insured depository institution other than an insured credit union appropriate to federal banking agency of such insured depository institution is defined in Section 3 of the Federal Deposit Insurance Act, Title 12, U.S. Code 1831, with respect to insured credit union and subsidiary insured credit union with the National Credit Union Administration. With respect to federal qualified non-bank payment stablecoin issuer that is not a national bank of the comptroller, and with respect to any and chartered by comptroller of the comptroller. B. Primary federal payment stablecoin regulators. The term primary federal payment stablecoin regulators mean the comptroller of the board of the incorporation and National Credit Union Administration registered public accounting. The term registered public accounting firm has meaning given the term under Section 2 of the Sarbanes-Oxley Act of 2002, Title 15, U.S. Code 7201. Term state means each of the several states of the District of Columbia and Territory of the United States. 20. State qualified payment stablecoin issuer. State qualified payment stablecoin issuer means that any of it is legally established, approved of the issue of the payment stablecoins by a state payment stablecoin regulator, issues a payment stablecoin in compliance with the requirements under Section 4. Stablecoin regulator with the term stablecoin regulator means state agency with the primary regulatory supervisory authority in such a state over the needs of the issue of the payment of stablecoins. State regulatory depository institution means a state regulated depository institution that has meaning given the State Depository Institution, Section 3A, Federal Deposit Insurance Act, Title 12, U.S. Code 1813C. Subsidiaries insured credit union, with respect to insured credit union, with the term subsidiary insured credit union means organization providing a service of the insurer of the credit union, the associated described in Section 107.7.1, Federal Credit Union Act, Title 12, U.S. Code 1757.7.1, and a credit union service organization. As such, term used in Part 712 of Title 12 Code of Regulations with respect to the insured credit union has ownership of the interest of which insured credit union has extended a loan. 3. Limitation of those who issue a payment in stable coins should be unlawful for any person with a permanent payment stablecoin issuer to issue a payment stablecoin in the United States. It is unlawful for any person other than a permitted payment stablecoin issuer to issue a payment of stablecoins in the United States. Section 4 requirements issuing payment stablecoins. Standing of the issuing of payment coins and generally permitted payment stablecoin issuer shall maintain reserve banking over the issuer payment stablecoins outstanding on at least one-to-one basis with a reserve compromising the United States coin currency, including federal reserve notes. Funds held with a demand deposit or other withdrawals may be withdrawn upon a request at any time with the insurer of the depository institution regulated to foreign depository institution. Insured share of the insurer of the depository institution subject to the limitations established with the corporation of the National Credit Union Administration, respectively to address safety, sound risk of the in-touch insurer of the depository institution, treasury bill notes and bonds. 1. With the remaining maturity of the 93 days or less, or issued with a maturity of 93 days or less, repurchase agreement maturity of 7 days less with the back with a treasury bill maturity of the 90 days or less. Reverse repurchase agreements of maturity of 7 days or less if it's collateralized by treasury notes, bills, or bonds overnight basis, subject to the over-collateralization in line with standard market terms that are tri-party, centrally cleared through a clearinghouse, bilateral with the counterparty, issue with a determined adequate credit worthy even in the event of severe market stress. Money market funds invested solely with the underlying assets described in clause 1 through 4, subparagraph 8, or central banking reserve deposits. Publicly disclose the issue of the redemption policy, establishing a public disclosure of the issue, redemption policy, establish procedure for the timely redemption of outstanding payment stable coins, establish a procedure for the timely redemption of outstanding payment stable coins, publish monthly composition of the issuer's reserve on the website of the issuer containing the total number of the outstanding with the payment stable coins issued with the issuer and the amount of composition reserve that is described under subparagraph A. Prohibition of rehypothecation. Reserves described in paragraph 1A may not be pledged, rehypotheticated, reused, except for the purpose of creating liquidity to meet with a reasonable expectation for the request for the redeemed payment stable coins. Such reserves in the form of treasury bills may be pledged in collateral for a repurchase with agreement maturity 90 days life provided with either. Repurchase agreements are cleared with a central clearing counterparty that is approved by primary federal and state payment stablecoin regulator. The permanent payment is stablecoin issued with the receipt of the primary approval of the primary federal, state, and payment stablecoin regulator. Monthly certification examination over reports registered public accounting firm. In general, the permanent payment of the stablecoin issued for each of the month have the information disclosed for the previous month end of the report under paragraph 1D for the examined registered public accounting firm certification. Each month of the chief executive officer, chief officer for the permanent payment stablecoin issuer shall submit certification as to accuracy with a monthly report. In primary federal payment stablecoin regulated, in this case state qualified payment stablecoin issuer, to the state payment stablecoin regulator. Criminal penalty: a person who submits certification required under subparagraph B, knowing that the such certification falls to the subject of the criminal penalty set forth in 350C of Title 18 United States Code, capital, liquidity, and risk management requirements. 4. In general, the primary federal payment stablecoin regulator should jointly, in the case of state qualified payment stablecoin issuer, state payment stablecoin regulator shall issue the capital requirements applicable to the permanent payment stablecoin issuer which not exceed the sufficient ensure the permanent payment stablecoin issuer's ongoing operation. Appropriate liquidated interest rate risk management standards applicable to the permanent payment stablecoin issuer which may not exceed what is sufficient to ensure the financial integrity of the permanent payment stablecoin issuer, the ability of the issuer to meet with the financial obligation issued with including redemptions, and 3. Appropriate operational compliance with information technology risk management standards, including Bank Secrecy Act, sanctions compliance, and tailored of the business model of the risk profile of the permanent payment stablecoin issue consistent with the other legal authorities. Rule of construction: nothing in this paragraph action is true of the limited authority of primary federal regulators prescribing standards under this paragraph, tailoring in a difference among issue on an individual basis or by category, taking into consideration capital structure, riskiness, complexity of financial activities, including financial activities of their subsidiaries, and size for any of the risk-related factors that are primary federal regulator determines appropriate, or supervisor regulator enforcement authority appropriate to federal banking agency for the safe sounding operation with an institution under supervision appropriate to federal banking agency. Applicability existing capital standards for the respective of the promulgation rules in subsection A1A section 171 of Financial Stability Act of 2010 Title 12 United States Code 5371A1A shall not apply. Treatment under the Bank Secrecy Act: a permitted payment stablecoin issuer shall be treated with as a financial institution for the purpose of Bank Secrecy Act limitations. Stable activities in general with a permitted payment stablecoin issuer may only issue payment stablecoins, redeem payment stablecoins, manage related reserves, including purchasing, holding reserve assets, provide custodial or safekeeping service of payment for the stablecoins required to preserve the private keys of the payment and stablecoins, or undertake other functions directly supported by the working issue of the redeeming payment stablecoins. Rules and construction: nothing in the subparagraph A shall prevent the permitted stablecoin issuer from engaging in non-stablecoin activities that are explicitly allowed by a relevant regulator. Regulation by the comptroller in general with the federal qualified non-banking stablecoin issuer shall be regulated extremely supervised exclusively by comptroller which have the authority and coordinate with the other relevant regulators to issue such regulation orders necessary to ensure safety and soundness of the issuer consistent with the provisions of the action conform to the amendment, forming an amendment in section 342B with the revised statute title 12 U.S. Standard Code 1B as amended, adding to the end of the following regulation of federal qualified non-bank payment stablecoin issue for the comptroller with the currency shall within coordination with relevant regulators issue such regulations and orders necessary to ensure the safety and soundness of the non-bank entity approved by the comptroller to issue payment stable coins. Once again, regulation of the federal qualified non-bank payment stablecoin issue of the comptroller of the currency shall coordinate with the other relevant regulators issue of the regulation order necessary to ensure the safety of the funds for the non-bank entity approved by the comptroller to issue payment stablecoins. State-level regulatory regimes. Option for the state-level regulatory regimes notwithstanding the federal regulatory framework established under subsection A of the stablecoin issue with a total market capitalization no more than $10 billion may opt for regulation of the state-level regulatory regime and provide the state-level regulatory regime and substantially similar to the federal regulatory framework under the subsection review. 2. Review. State regulators shall review the state law regulatory regimes according to criteria state regulators establish in determining whether a state-level regulatory regime is substantially similar to the federal regulatory framework under subsection A. Certification. Initial certification subject to subparagraph B no later than the first year of the day of the enactment. The state of the regulators will submit with the Secretary of the Treasury with the initial certification that their state-level regulatory regime meets the criteria of substantial similarity under paragraph 2. Form of certification. Initial certification required under subparagraph A shall contain with the form prescribed by the Secretary of the Treasury for the attestation that the state-level regulatory regime meets the criteria that is substantially similar under paragraph 2. Annual recertification no later than the date of the determined secretary each of the year of the state shall submit to the Secretary of the Treasury with additional certification that confirms accuracy. Initial certification subparagraph submitted under subparagraph A not substantial similar in general and state regulatory does not meet with the certification on paragraph 3 with the payment of stablecoin issue operating under the subsection still subject to the federal regulatory framework as described in subsection C but notwithstanding the market capitalization and hair threshold therein. Treasury review. Secretary of the Treasury may reject certification under paragraph 3 as Secretary determines for the state level the regulatory regime is not substantial similar to the federal regulatory framework or in subsection A, but the payment of stablecoin issuers shall be subject to federal regulatory framework described in subsection EC, but notwithstanding market capitalization threshold therein. Appealated review of payment of the stablecoin issuer that may challenge the determination state regulatory secretary trained treasurer under the paragraph of the United States District Court of the District of Columbia. The list of the Secretary Treasurer shall the published maintained on the Federal Register of the website of the Department of Treasury. List of the state of the submitted with the initial certification, recertification on paragraph 3, transition, federal regulation, depository institution, state regulatory depository institution that has been approved of the payment stablecoin issue with a market capitalization more than $10 billion. So within no later than 360 days after reaching such market capitalization translation regulation of the federal regulatory framework over the board or beginning with the date of reaching market capitalization sees the issue with the new stablecoins until the state regulated stablecoin issue is under the $10 billion market capitalization threshold. Other institutions, state qualified payment stablecoin issue not described in paragraph 1 over the market capitalization of more than $10 billion shall no later than 360 days after the reaching such market capitalization transition regulatory with under the regulatory framework of the comptroller over the beginning of the day of the reaching such market capitalization cease issuing the new stable coins until the state regulated stablecoin issue with the under $10 billion market capitalization threshold. Conditional approval upon filing the application appropriate federal regulatory state qualified payment stablecoin issuer shall be deemed conditionally approved and pending final approval of the denial application waiver the applicable federal regulatory may waive the requirement of paragraph 1 or 2 state qualified payment stable coins issue to remain state level regulatory regime rulemaking in general. The rulemaking 1 in general with the primary federal payment stable coin regulators, state payment stable coin regulators may issue with such order the regulation necessary for the administrator to carry out the requirements section, including established condition or to prevent evasion through of the joint issuance of the regulation. All of the regulation issue of the carry out of the section shall be issued joint by the primary federal payment stablecoin regulator if not used in state payment stablecoin regulator rulemaking deadline no later than the end of the 180-day period beginning on the day of the enactment of the act. The federal payment stablecoin regulatory shall issue for the regulation carry out this section. Section 5. Approve the subsidiaries and ensure the depository institution federal qualified non-bank payment stablecoin issuers application. But Section 5, approval of subsidiary insured depository institution federal qualified non-bank payment stablecoin issuers. A. Application. In general, the primary federal payment stablecoin regulator shall review and receive the review, approve of the application, ensure the depository institution, ensure the issue of the payment of the stablecoin through the subsidiary, any non-banking entity, seek the issue of the payment stablecoin. The primary federal payment stablecoin regulator shall establish a processing license and regulating of the entity's authority of the issue of the regulation process of the application. Primary federal payment statement stablecoin regulator shall be before the effective date described in 16 of the issue regulation carrying out this section with the pursuit of the regulation described in subparagraph A, except process application under this act with the mandatory approval of the process of the primary or the federal payment stablecoin regulator shall be upon the receipt of complete application evaluate, make determination on each application based on the criteria established under this act. Evaluation of the applications, complete application received under section A shall be evaluated by primary federal payment stablecoin regulator. U of the factors described in subsection C. Factors shall be to be considered. Factors described in subsection ability of the applicant. In this case, the applicant that is an insured depository institution subsidiary of the applicant based on financial condition, resources to meet the requirements in section set forth in section 4. Timing the decision grounds for denial. Timing the primary federal payment stablecoin regulator shall render the decision of applicant for no later than 120 days. Inform the applicant is complete of the denial application grounds of the denial of the primary federal payment stablecoin regulator shall only be denied with the complete application received under the subsection A if the regulator determines if the activity of the application would be unsafely unsound based on the factors prescribed in section C. Explanation required if the primary federal payment stablecoin regulator determines denies complete application received under subsection A no later than 30 days after the date of such denial. The regulator shall provide the applicant written notice explaining the denial specificity, including all the findings made by the regulator with respect to identified material shortcomings in the application, including actionable recommendations on how application could be addressed, identified the material shortcomings after turning over the hearing of the final determination. In general, no later than 30 days after the day of the receipt of the notice of the denial application under this section, application may request the written and the opportunity with the written oral hearing before primary federal payment stablecoin regulator to appeal with the denial of the timing with upon receipt with a timely request primary the federal payment stablecoin regulator shall notice at the time no later than 30 days after the day of the receipt of the request place at which the applicant may appear with a personally thoroughly counsel to submit with the written material to provide oral testimony, oral argument, final determination. Note that later than 60 days after the hearing, after the day of the hearing under the subparagraph of the primary federal payment stablecoin regulator shall notify the applicant final determination over the comptroller which over the contain of the statement of the basis of the determination specific findings. Notice of the if no hearing if the applicant does not make for the timely request hearing with the subparagraph primary federal payment stablecoin regulator shall notify the applicant no later than 10 days of the day of which the applicant requests the hearing under the subparagraph in writing of the denial applicant with a final determination primary federal payment stablecoin regulator failed to render a decision. If the primary federal payment stablecoin regulator failed to render the decision complete application within the time period specified in the paragraph 1, application shall be deemed appropriate right to reappeal the denial of the application within this section shall not prohibit the applicant from the filing subsequent application. Reporting on a pending application with the comptroller shall annually report that the Congress application have been pending 6 months or longer date with the initial application filed within subsection A, where the applicant has informed that the applicant remains incomplete with including providing with the documentation status of the application while the application has not yet been approved. Rulemaking of the comptroller shall issue for the rules necessary for the regulation of the issuance of the payment of stablecoins, but may not impose requirements inconsistent with the requirements specified in Section 4. Section 6, supervision enforcement with respect to subsidiaries ensure the depository institutions. Supervision enforcement with respect to subsidiary insured depository institution and comptroller regulated entities. Supervision A. Supervision 1. Subsidiary and insured depository institutions. In general, each pyramided payment stablecoin issued for the subsidiary and insured the depository institution shall be charged with the supervision primary federal payment stablecoin regulator in the same manner as such insured depository institution. Gramm-Leach-Bliley Act. For the purpose of 5 of the Gramm-Leach-Bliley Act, the Title 15 U.S. Standard Code 6801, each attempt sequence, each permitted with a payment stablecoin issued with a subsidiary of the insured the depository institution shall be deemed with the financial institution comptroller regulated entities. Submission of the reports, each comptroller regulated entity shall have upon the request submit the reports to comptrollers to the financial condition of the comptroller regulated entity system of the monitoring, controlling financial operating risk compliant with the comptroller regulated entity, any subsidiary thereof which is with this act. Examination comptroller making an examination of comptroller regulated entity, each subsidiary subsidiary of each entity in order to inform the comptroller of the nature of the operation of the financial condition, comptroller of the regulated entity, financial operation, or the risk of the comptroller of the regulated entity may pose threat with the safety and soundness of the comptroller of the regulated entity, stability of the financial system in the United States, of the system of the comptroller of the regulated entity, with the monitoring, with the controlling of the risk described in Section 2, requirements of the efficiency, using existing reports and supervised, examining comptroller of the regulated and Comptroller shall, to the full extent possible, use existing reports or other supervisory information. Avoidance of duplication. Comptroller shall, to the fullest extent of the possible, and avoid duplication, examination, activity, reporting requirements of the request for the information, and carry out this act with the comptroller regulated entity with the consideration of the burden. Comptroller shall, with the respect for the examination request for the submission of the report under paragraph A of the request examination report with the cadency within a format similar to those required in similar situated comptroller regulated entities. Enforcement. Suspension of the revocation registration. Primary federal payment stablecoin regulator may prohibit the permitted payment of stablecoin. A permitted payment of the stablecoin issue of the firm issuing payment is sub stablecoins if the primary federal payment stablecoin regulator determines that such permitted payment stablecoin issue of the institution affiliated part of the permitted payment stablecoin issuer is materially violating or has materially violated the act of any regulation or order issued under this act, or materially violating or materially violated any condition of imposed in writing with the primary federal payment stablecoin regulator connection with the written agreement entered between the permitted payment stablecoin issue with the primary federal payment stablecoin regulator. Case and desist of proceedings if the primary federal payment stablecoin regulated reasonable cause of the belief of the permanent payment stablecoin issue of the institution affiliated party of the permanent payment stablecoin issue of the violating has violated it or is attempting to violate the act, any of the regulation or order issued under this act, any written agreement entered into the issued under this act, the written agreement entered with the primary federal payment stablecoin regulator or condition imposed with the writing of the primary federal payment stablecoin regulator in connection with the application of the request primary federal payment stablecoin regulator made by provisions that are mandatory, otherwise are ordered permitted payment stablecoin issue with the or institution affiliated party of the permanent payment stablecoin issuer to the cease and desist of such violation or practice, or the take an affirmative action to correct with the condition making with the form 8 such violation practice. 3. Remove of the prohibition of the authority. Primary federal payment stablecoin regulator may remove the institutional affiliated party from the permitted payment stablecoin issue from the position of the officer or prohibit the participation in affairs of the permitted payment stablecoin issue with all permitted payment stablecoin issue by such institution affiliated party with the primary federal payment stablecoin regulator determines that an institution affiliated party have directly indirectly committed a violation, attempted violation of this act with a regulation in order to issue of this act. Institution affiliated party have committed violation of the provisions subchapter 2, chapter 53, title 31, United States Code. Procedures. In general, the primary federal payment stablecoin regulator identified with the violation, attempted with the violation, act of the make of the determination under paragraph 1 or 2 or 3 of the federal payment by primary federal payment stablecoin regulator comply with the procedures set with the fourth of subsection B and E, section 8 of the Federal Deposit Insurance Act of Title 12 U.S.N. Code 1818. Judicial review. A person with aggrieved by the final action or in subsection may obtain judicial review such action exclusive of the provided in section 8H of the Federal Deposit Insurance Act, Title 12 U.S.N. Code 1818H. Injunction of the primary federal payment stablecoin regulator may, in discretion of the regulator, file with the procedure provided in 811 Federal Deposit Insurance Act for the judicial enforcement of any activity outstanding in the notice of the order issued in subsection temporary cease and desist proceedings if the primary federal payment stablecoin regulator determines the violation, attempted violation of its act, and action with respect to the determination was made on paragraph 1, 2, or 3 of the continuation is likely to cause insolvency of a significant dissipation of the assets or earnings of permitted payment stablecoin issuer is likely to weaken the condition of the permitted payment stablecoin issuer for the otherwise prejudice the interest of the customer of the permitted of the payment stablecoin issuer prior to the completing of the proceedings conducted with the paragraph. Primary federal payment stablecoin regulator may file with the procedure providing in section 8C of the Federal Deposit Insurance Act, Title 12 U.S. Code 1818C to issue temporary cease and desist order. Civil money penalties, failures to approve any person who issued the United States dollar denomination payment stablecoin who is not permitted to payment stablecoin issued with any institution affiliated partner of such a person who knowingly participates in issuing a payment stablecoin shall be liable to civil penalty not more than $100,000 each day during this payment the stablecoins are issued. First area, except for providing subparagraph a permitted payment stablecoin issue for the institution affiliated party to such permitted payment stablecoin issue for the materially violates the act of any regulation ordered issued under this act with the materially violates any of the condition issued for the written with the primary federal payment stablecoin regulator in connection with a written agreement entered between the permitted payment stablecoin issue from the primary federal payment stablecoin regulator should be liable for the civil penalty of $100,000 each day during the violation continues. Secondary, except for providing subparagraph A in addition to the penalty described in subparagraph B with the permitted payment stablecoin issued for the institution affiliated party, such permitted payment stablecoin issued for the knowingly participates in violation of the provision of the act and regulation ordered to issue they are under liable with a civil penalty up to the additional $100,000 each day during the violation continues. Procedure: any penalty imposed on the paragraph may be assessed and collected by the primary federal payment stablecoin regulator pursuant to the procedure of the set forth of the 812 Federal Deposit Insurance Act, Title 12 U.S. Standard Code 18.18.12. The notice of the other approval after separation from service, resignation, termination of the employment, of the participation, separation from the institution affiliated party, including separation clause with the closing permitted payment stablecoin issuer shall not affect the jurisdiction authority of the primary federal payment stablecoin regulator to the issue of the subsection against any such party for the notice of order and service to the end of the 6-year period beginning with the day with such party has ceased to be an institution affiliated party with respect to such permitted payment stablecoin issuer. Non-applicability statement is a qualified payment stablecoin issuer. The subsection shall not apply to state qualified payment stablecoin issuer. Section 7. State qualified payment stablecoin issuer. In general, the state payment stablecoin regulator shall have supervised examination enforcement authority for the state qualified payment stablecoin issuer of such state. Authority to enter into agreements within the board of state payment stablecoin regulator may enter the memorandum of the understanding within the board mutual agreement under which the board may carry out supervision examination enforcement authority with respect to the state qualified payment stablecoin issuer on such statement. Sharing of the information state payment with the stablecoin regulator board shall share the information on an ongoing basis with respect to the state qualified payment stablecoin issuer of such state, including a copy of the initial application and any of the accompanying with the documents rule making statement. Payment stablecoin regulator may issue the ordered rules on subsection 4 with the applicable to the state qualified payment stablecoin issuer to the same extent with the primary federal payment stablecoin regulator issue orders. Rules under section 4 are applicable to permanent payment stablecoin issuer that are not in the state qualified payment stablecoin issuer. Enforcement authority and extinction of the circumstances. Board in general substance of the paragraph C with an extingent circumstance of the board may act for no later than 5 days prior to written notice. Applicable state payment stablecoin regulator take an enforcement action against state qualified payment stablecoin issue with an institute or an instituted affiliated party of such issue of the violation act for the extension of the nature. Rule making no later than the end of the 100 days after the beginning of the date of the enactment of the act. For the board shall issue the rule set forth with the extension of the circumstances of the board may act under this paragraph. Limitations: if the board determines that reasonable cause to believe the continuation of state qualified payment stablecoin issue for the activity continue with the share of the risk, financial safety, soundness, stability with the stablecoin issue for the boards may impose the restriction as the board determines necessary to address such restrictions. Such restrictions shall be issued in the form of a directive with the effect of a cease and desist order with becoming a final with the state qualified payment stablecoin issue for any of the affiliates, limiting the payment of the dividends. The payments for the dividends by the state qualified payment stablecoin issue for the transaction between state qualified payment stablecoin issue for the holding company, subsidiary, and affiliates, either with the state qualified payment stablecoin issue of the holding company with and any activity of the state qualified payment stablecoin issue that might create a serious risk of liability to the holding company with the affiliate with the holding company may be imposed on the state qualified payment stablecoin issue of the review of the directive of the administrative review and in general with the after the directive described in paragraph C with the issue of the state qualified payment stablecoin issue of the affiliate state qualified payment stablecoin issuer subject to the directive may object present to the board in writing. Reason for the directive should be modified and resigned. Automatic lapse of this directive if after 10 days after the receipt of the response directive described in subparagraph clause 1 the board does not affirm or modify or resign the directive shall automatically lapse judicial review. In general, the board affirms if modified by the directive pursuant to the clause of the effective of the party made immediately thereafter, petition the United States District Court for the District of the main office of the effective authority located within the United States District for the District of Columbia State modified by the terminate and set aside by the directive. Relief of the extraordinary causes upon showing of the extraordinary cause an affected party may petition on the relief under subclause without the first pursuing exhausting the administrative of the remedies under clause 1. Comptroller in general, subject to subparagraph C, with the extension of the circumstance of the comptroller shall have not less than 5 days prior to the written notice the applicable statement to the table of the calling regulator, taking enforcement action against the comptroller regulated entity, the institution affected party with such of any violation of the act rule making no later than the end of the 180 days prior to the beginning of the day of the enactment of the comptroller shall issue the set forth the extension of the circumstance to which the comptroller may act on the paragraph limitations. If the comptroller determines if the reasonable cause to believe of the continuation comptroller of the regulated entity of the activity constituted with the serious risk of the financial safety, soundness, and stability of the stable coin issue of the comptroller shall issue the such restriction if the comptroller determines being necessary to address such risk. Such restriction shall be the issue of the form of the directive of the fact that the chief of this order becomes final with the state qualified payment stable coin issuer, any affiliates, limitation, payment of dividends, whether the comptroller regulated any transaction between the comptroller regulated any holding company subsidiary affiliates of the other comptroller regulated entity of the holding of the company of any activities of the comptroller regulated entity of the microwave with the shares risk of the liabilities holding of the company affiliates of the company may be imposed with the comptroller regulated entity. Review of the directive of the administrative review and generally after the directive of the described in some paragraph C issue with the comptroller regulated entity with the affiliate with the comptroller regulated entity of the subject of the directive of the may object with the president with the comptroller with the writing with the reason with the directive should be modified with the resign automatic lapse of the directive that after 10 days after the receipt of the response that describes subclass 1 of the comptroller does not affirm with the modified with the resign with the directive shall automatically lapse judicial review. In general, the comptroller affirmed with the modified with the directive with the pursuant of the clause 1 and the effect of the party made immediately thereafter for the petition of the United States of the District Court of the District which may with the office for the effect of the party located with the United States of the District Court of the District Columbia to stay with the modified terminated set aside with the directive leave of the extraordinary cause of the upon showing of extraordinary condition effective party with any petition of the relief of the subclause of the first pursuing exhausting the administrative of the remedies under clause 1. Gromany, Leach, and Biley Act for the purpose of Title 5 of the Graham, Leach, and Biley Act of Title 15, United States Code 6801. 10 sequence of state qualified payment stablecoin issuers that deemed financial is deemed a financial institution effect on state law. Effect on state law. Effect on state law. Host state law with the consumer protection with the generally apply with the operation payment of stablecoin issue the host state apply with the activity conducted with the host state by an out of state qualified payment stablecoin issue with the same and the similar applies requirements of applies to the activities conducted in the host state by an out of state federal qualified non-bank same payment stablecoin issuer. Home state law if the home state law will determine not apply with the other paragraph or one of the laws of the home state with the payment of stablecoin issuer shall be the government the activities of the payment of stablecoin issuer conducted in the host state. Section 8 Consumer Protection General the person may only engage in the business of providing custodial and safekeeping services for the permitted payment stablecoins or private keys permitted payment stablecoins if the person is subject to supervision regulation primary federal payment stablecoin regulated primary federal financial regulatory agency described under subsection B and C of section 212 of the Dodd-Franklin Wall Street Reform Consumer Protection Act Title 12 U.S. Stand Code 530112 or supervision state bank supervisor defined under section 3 Federal Deposit Insurance Act, or state creditor union supervisor of the defined under Section 6003 Anti-Money Laundering Act of 2020. Such state bank supervisor or state credit union supervisor make available to the board such information boards determine the necessary relevant in that categories information in subsection D. Applies segregation requirements under subsection B unless such person complies with similar requirements required by primary federal payment stablecoin regulator, Security Exchange Commission, Commodity Further the Trading Commission, Creation requirement. A person with the described in subsection A shall retrieve with a deal with the payment of stablecoin of the private key for the other property of the person for the whom and whose behalf person receives, requires, and holds payments of stablecoin, private keys, and cash out of the property herein in this section referred to as customer, as belonging to such customer, and to take steps that appropriately protect with the payment stablecoin, private keys, cash out of the property customer of the fails to claim of the creditor of the person commingling prohibited. In general, the payment in stablecoin, cash, and other property of the customer shall be separately with the company accounted for by a person described in subsection A, and shall not be commingled with the funds of the person with funds of the person. Exemption notwithstanding paragraph 1, at the payment of stablecoin, cash, and the other property of the customer may be the convenience of the commingled with the deposit of the omnibus account with the holding of the payment of stablecoin, cash, other property more than one customer with the added insurance depository institution trust company. Such share of the payment of stablecoin, each cash over the property customer with a share of the necessary transfer of the just and settle with the transaction transfer asset withdrawn with applied for such purpose to include the payment of the commission of the taxes, storage, other charges lawfully acquiring with a connection with the provision services by a person described in subsection A. C. In accordance with such term of the condition of the board may prescribe with the rule, regulation, and order with the need of the customer payment stable coin cash over the property described in the subsection with the may be commingled with the deposit of the customer accounts with payment stable coins cash over the property received with the person required for the board to be separately accounted for but retrieved with the dealt with as belonging with the customer regulatory information. A person of the described under subsection A shall submit the applicable primary regulatory information concerning the person, business, operation, process of the protect with the customer, asset in such form with the manner of the primary regulator shall determine exclusion requirements of this section shall not apply with the person solely on the basis such person engaged with the business providing hardware or software to facilitate customers' own custody and safekeeping with the payment, stablecoins, or private keys. Section 9, treatment insolvent payment stablecoin issuers. In general, the insolvency proceeding, with including proceedings under Title 11 of the United States Code, insolvency proceeding with a primary federal payment, stablecoin regulator, state banking or a state banking supervisor will respect the payment. Respect to a payment stablecoin issuer claim of the person holding payment stablecoins issued by the payment stablecoin issuer shall have the authority priority over all the other claims against the payment stablecoin issuer. Priority in bankruptcy proceedings. Secretary 507 Title 11 of the United States Code is amended. Subsection A with the striking of the following, the inserting subsection E of the following, and adding to the end of the following, notwithstanding subsection A with the claim of the person holding the payment stable coins is defined in subsection 2 of guiding establishing national innovation for the U.S. stablecoins of 2025 issued debitor to have the first priority ever over any other claim against the debtor under this title. Debitor, a person payment is a stablecoin issuer of the non-depository institution defined in section 3 of the Federal Depository Insurance Act, Title 12 U.S. Code 1813, may be considered the debitor under Title 11 United States Code. Section 10, interoperability standards, primary federal payment stablecoin regulators, consultation with the National Institution Standard Technology Relevant Standard Setting Organization State Government shall asset necessary made pursuant to Section 553 of Title V in manner of the consistent with the National Technology Transfer Advancement Act of 1995, Public Law 104-113, prescribed standards of the payment stablecoin issue of the promote incompatibility and operability. Section 2, studying endogenously collateralized stablecoins. Study by the Treasurer. The Secretary of the Treasury of the Consolation of the Board of the Comptroller of the Corporation Security Exchange Commission shall carry out the study of the endogenous collateralized stable coins. For no later than 360 days after the date of the enactment, the Secretary shall provide with the Committee of Financial for the House, a representative of the Committee of the Banking, Housing, Urban Affairs with the Senate, a report with it containing with all the findings of the carrying out of the study with the paragraph 1, including with the analysis of the categories of the non-payment attainment coins, including with the benefit of the risk of the technology design features. Participation in non-payment and stablecoin arrangements, potential utilization, non-payment and stable coins, nature of the reserve composition, the type of the algorithms being employed with the governance structure, with including aspects of the decentralization, nothing public promotion, advertising, collaterally available to the consumer the notice of the disclosure. Endogenous collateralized stablecoins defined. In this section, the term endogenous collateralized stablecoins means any digital asset in which the originator represented with converted, redeemed, or repurchased of the fixed amount with the monetary value of the relies solely on the value of another digital asset created with or maintained by the same originator or maintain fixed price. Section 12 reports rulemaking status no later than 6 months after the day of the enactment act of the primary federal payment stablecoin regulator shall provide a status update development and rulemaking under the act of the Committee on Financial Services House of Representatives Committee on Banking, Housing, and Urban Affairs of the Senate. Annual reporting requirements for the beginning of the day of the first year after the day of enactment of the annually with the Board of the Comptroller submitted to the Committee of the Banking, Housing, and Urban Affairs of the Senate of the Committee of the Financial Services House of the Representative Directive Office of Financial Research. A report says payment stablecoin industry, including an overview trends of the payment stablecoin activity summary for the number of application permitted payment stablecoin issued under subsection 5, including aggregated approval of rejections of the applications and a description of potential financial statement of stability risk posed to the safety of the soundness of the broader financial system by payment of stablecoin activities. So the FSOC report, Financial Stability Oversight Council, shall incorporate findings in the report under subsection B of the annual report of the Council required in section 112 to A to the N of the Dodd-Frank Wall Street Reform Act, Consumer Protection, Title 12, U.S. Standard Code 5322. Section 13, Authority of the Banking Institution Rule of Construction. Nothing in this act may be construed to limit the authority of depository institution, federal credit union, state credit union, or a trust company to engage in activity permissible pursuant to the applicable state federal laws, including accepting and receiving the deposit, the issuing of the digital asset for the representative deposit, utilizing the distributed ledger for the looks of the record of the effect of the interbank and transfer. Accepting and receiving the deposits, issuing the digital assets from that represent the deposits, utilizing distributed ledger for the books and the record of the effect of the intra-bank transfer, and providing custodial service for the payment of stablecoins, private key for the payment of stablecoins, or reversing back payment stablecoins. Treatment of custody activities with the appropriate federal banking agency as defined under Section 3 of the Federal Deposit Insurance Act of Title 12 U.S. Code 1813. National Credit Union Administration, in the case of the Credit Union Secretary Exchange Commission, may not require of the depository institution, national bank, federal credit union, or state credit union, or trust company, or an affiliate thereof, to include assets that hold custody of liabilities with any financial statement or balance sheet, including payment stablecoin custody of safekeeping activities, and to hold additional regulatory capital against the asset of the custody of safekeeping, except the necessary to mitigate against the operational risk of the inherent with the custody of safekeeping service determined by the appropriate federal banking agency with the National Credit Union Administration, invasive of the credit union, state bank supervisor of the defined under Section 3 of the Federal Deposit Insurance Act, Title 12 U.S. Standard Code 1813, state credit union supervisor defined under Section 6003 Anti-Money Laundering Act of 2020, recognize liability for obligation related to the activities of the performed the digital asset for the end if it does not own if the liability would accept the expense of the recognized income statement to resolve the corresponding obligation. Definitions in this section: depository institution. Term of the depository institution has a meaning given to that. The term under Section 3 of the Federal Deposit Insurance Act of the Title 12 U.S. Code 1813. Credit union terms. Terms federal credit union, state credit union have the meaning given to those terms of the respectively under Section 101 Federal Credit Union Act. Section 14 amendments clarify the payment of the stablecoins on security of the Commodities Investment Advisors Act of the 1940, Section 202A18 of the Investment Advisors Act of 1940, Title 15 U.S. Code 80B2A18 is amended with adding at the end of the following the term security that does not include the payment of stablecoin the issue for the permitted payment stablecoin issue for the terms that are defined respectively in Section 2 for the clarity of the Payment Stablecoin Act of 2023, Investment Company Act 1940, Section 2A36 for the Investment Company Act 1940, Title 15 U.S. Code 280A2A336 is amended by adding an end of the following the term security does not include the payment of stablecoin issue for the permitted payment stablecoin issue for the rest of the terms defined in the respectively Section 2 of the clarity of the Payment Stablecoins Act of 2023. Securities Act of the 1933, Section 2A1, with the Security Act of the 1933, Title 15 U.S. Stand Code 7 B A1 is amended with the adding with the end of the following with the term of the security that does not include the payment of stable coin issue for the permanent payment of stable coin issue such for the terms of defined in the respectively Section 2 with clarity of the Payment Stable Coins Act of 2023, Security Exchange Act of the 1934, Section 3A10, Security Exchange Act of the 1934, Title 15 U.S. Stand Code 78 CA10 is amended to adding of the end of the following the term security does not include the payment of stable coin issue for the permanent payment stable coin issue for the term of the defined with the respectively Section 2 with the clarity of the payment of the sub-stable coin with the Act of the 2023. Security Investor Protection Act of the 1970, Section 1614, Security Investor Protection Act of the 1970 is amended with the adding with the end of the following the term security does not include payment stablecoin issue for the permanent with the payment stablecoin issue for the stuff the terms are defined with the respect of Section 2 clarity of the Payment Stablecoins Act of the 2023, Section 15 reciprocity of the stablecoins issued overseas with the jurisdiction. Federal Reserve in collaboration Secretary of the Treasury should create with the implement reciprocal arrangements over the other bilateral agreements between the United States and jurisdictions over the substantial similar payment of stablecoin regulatory regimes and facilitate the international transaction interoperability of the same United States dollar denominated stablecoins issued overseas. And effective with the date and generally the act shall be taken effect for the early with the 18 months of the enactment with the act with the day with 128 days of the day with the primary federal payment stablecoin regulator issued and final regulations implementing the act. Notice with the Congress of the primary federal payment stablecoin regulator shall notify the Congress of the time of the beginning of the process of the application of the end of this act. The safety harbor of the pending of the application of the primary federal payment stablecoin with the regulators may waive the application requirement of the act for the period of the exceed with the 12 months of the beginning with the effect of the day with the described under subsection A, where the respective subsidiary ensure of the depository institution ensure the depository institution has an application pending with the subsidiary to become a permitted payment stablecoin issue with the effect of the day with the non-banking entity with the application pending with the become with the competitor regulated entity with an effect of the date.